was held that tax on the gift of land is not a tax imposed directly on land, but only on the particular user, namely the transfer of land by way of gift. In Union of India versus Dhillon, this court approved the principle laid down in Non as well as Nazareth. In Bhagwan Das Jain, this court made a distinction between levy on income from house property, which would be referable to entry 49 list 2. It is therefore not possible to accept Mr. Krishnamurthy's submission that the cess on royalty cannot possibly be said to be a tax or an impost on land. Mr. Nariman is right that royalty which is indirectly connected with land cannot be said to be taxed directly on land as a unit. In this connection, a reference may be made to the differentiation made to the different type of taxes for instances, one being professional tax and entertainment tax. In Western India theatres, it was held that the entertainment tax is dependent upon whether there would or would not be a show in cinema house. If there is no show, there is no tax. It cannot be a tax on profession or calling. Professional tax does not depend upon the exercise of one's profession, but only concerns itself with the right to practice. It appears that in the instant case also, no tax can be levied or is leviable under the impugned act if no mining activities are carried on. Hence, it is manifest that it is not related to land as a unit, which is the only method of valuation of land under entry 49 of list 2, but is relatable to minerals extracted. Royalty is payable on a proportion of the minerals extracted. It may be mentioned that the Act does not use dead rent as the basis on which land is to be valued. Hence, there cannot be any doubt that the impugned legislation in its pith and substance is a tax on royalty and not on land. Now, in my humble submission, note, this is completely erroneous, because your Lordship saw in 9A that dead rent or royalty in the alternative, whichever is higher. The court seems to be saying, had it been dead rent instead of royalty, it would have been all right. But since royalty has been brought there, therefore it is. And the other aspect, note, is that since it is dependent upon use, now the fact that land is being used or not used can be a classification method, because government will not like to tax the land where for some good reason mining is not being done. So it's not always that once the aspect of user comes in, therefore it automatically goes out of the fold of entry 49, list 2. Then kindly come to 24 at page 116. On behalf of the state of Tamil Nadu Learned Council, Mr. Krishnamurthy Iyer sought to urge that it can also be sustained under entry 50 list 2. Entry 50 of list 2 of the 7 schedule deals with taxes on mineral rights, subject to limitation imposed by Parliament relating to mineral development. Entry 23 of list 2 deals with regulation of mines and mineral development subject to the provisions of list 1 with respect to regulation and development under control of the Union. And entry 54 in list 1 deals with regulation of mines and minerals under the control of the Union declared by Parliament by law to be expedient in public interest. Even though minerals are part of the state list, they are treated separately. And therefore, the principle that the specific excludes the general must be applied. See the observations of Waverley Jute Mills, where it was held that land in entry 49 cannot possibly include minerals. Please mark this sentence, my lords. It will not include minerals, not that it will not include the land itself. In this connection, learned Attorney General appearing for the Union of India submitted before us that in order to sustain the levy, the power of the state legislature has to be found within one or more of the entries of list 2 of the 7 schedule. The levy in question has to be either a tax or a fee or an impost. If it is neither a tax nor a fee, then it should be under one of the general entries under list 2. The expression land, according to its legal significance, has an indefinite extent both upwards and downwards. The surface of the soil and would include not only the face of the earth, but everything under it or over it. Now, this is in support of the states. It doesn't go against. See the observations in Anant Mills. The minerals which are under the earth can, in certain circumstances, fall under the expression of land. But as tax on mineral rights is expressly covered by entry 50 list 2, if it is brought under the head taxes under entry 49 of list 2, it would render entry 50 of list 2 redundant. Learned Attorney General is right in contending that the entry should not be so construed as to make one entry redundant. It was further argued that even in pith and substance, the tax fell to entry list 50 list 2. It would be controlled by a legislation under entry 54 list 1. Now, there is only one problem with these observations, that Mr. Krishnamurthy wanted to justify the tax in the alternative under entry 50 list 2, saying therefore that it can be, cess on royalty can be understood since royalty is relatable to extracted mineral and dispatched mineral. Therefore, it is very proximate in nexus with entry 50 list 2. Now, what the court is saying, that the minerals which are under the earth can in certain circumstances fall under the expression land. So if it either falls under land or it falls as a mineral right. So either it goes under 49 list 2 or it comes within the fold of entry 50. If it comes under 50, then the state is competent subject to the limitations. On the other hand, Learned Attorney General submitted that if it be held to be a fee, then the source of power of the state legislature under entry 66, read with entry 23 list 2, here also the extent to which regulation of mines and mineral under the control of the union is declared by parliament by law to be expedient in public interest, to the extent such legislation makes provision will denude state legislature of the power to override the provision of entry 50 list 2. Now this again, in my humble submission, is completely erroneous. 54 will not denude, it will not enable parliament to arrogate to itself any power of tax. In view of the parliamentary legislation under entry 54, declaration made under section 2 and provision of section 9 of the act, the state legislation would be overridden to that extent. It's completely erroneous in my respectful submission, because it assumes that section 9 is a tax and tax pertaining to entry 50 list 2, and it is a limitation on that, and therefore denudation happens. Then they refer to Hingir Rampur and also the observations of the state of Odisha versus Tulak. Our attention was drawn to the decision of the division bench judgment of the High Court of Mysore in Lakshmi Narayan Mining Company. There, speaking for the court, one of us, Justice Venkatramaya of the Mysore High Court, as the learned Chief Justice then was, observed that a combined reading of entry 23 and 50 of list 2 and entry 54 establishes that as long as the parliament does not make any law in exercise of its power under entry 54, the powers of the state legislature in entry 23 and 50 would be exercisable by the state legislature. But once the parliament makes a declaration by law that it is expedient in the public interest to make a regulation of mines and minerals development under the control of the union to the extent to which such regulation and development is undertaken by the law made by parliament, the power of the state legislature under 2023 and 50 list 2 are denuded. 23 is understandable. But entry 50, unless one finds a specific express limitation in the MMDR Act made under entry 54, will not be either denuded or abstracted for me. Abstraction is absolutely not possible. Limitation is possible.
So this has to be read in the context of the facts of that case. There it was a license fee. A license fee was held to be royalty. But here the interpretation of that judgment is very wide.
Yes. And that has led to the errors in this case. I'm grateful, I'll place that case also before your lordship. To the similar effects of the observations of the High Court of Patna, that High Court of Patna, this para I'm not reading because Patna has been followed in the Karnataka case, and when I place that Mysore case, then in para 29, HRS Murthy is referred, and this was overruled in this by this 7 judges judgment. So let me place this extracted part of HRS Murthy. When a question arises as to the precise head of legislative power under which a taxing statute has been passed, the subject for inquiry is what in truth and substance is the nature of the tax. No doubt, in a sense, but in a very remote sense, it has a relationship to the mining as also to the mineral won from the mine under a contract by which royalty is payable on the quantity of mineral extracted. But that does not stamp it as a tax on either the extraction of the mineral or on mineral right. It is unnecessary for the purpose of this case to examine the question as to what exactly is a tax on mineral rights, seeing that such a tax is not leviable by Parliament, but only by the state, and the sole limitation on the state's power to levy the tax is that it must not interfere with a law made by Parliament as regards mineral development. Our attention was not invited to the provisions of any such law created by Parliament. In the context of Section 78, 79 and the scheme of those provisions, it is clear that the land cess is in truth a tax on land within entry 49. So HRS Murthy did not see Section 9 as a tax or a limitation on entry 50. It seems, therefore, that the attention of the court was not invited to the provisions of the Mines and Mineral Development and Regulation Act and Section 9 thereof. Section 9(3) of the Act in terms states that royalties payable under the second schedule of the Act shall not be enhanced more than once during the period of 4 years. It is therefore a clear bar on the state legislature taxing royalties so as to in effect amend second schedule of the Central Act. In the provision, it cannot be right to say that tax on royalty can be a tax on land. And even if it is a tax, if it falls within entry 50, it will be ultra vires the state's legislative power in view of Section 9(3). In Hinger Rampur versus State of Odisha, Justice Vanchu in his dissenting judgment has stated that a tax on mineral rights being different from duty of excise pertains only to a tax that is leviable for the grant of right to extract minerals and is not a tax on minerals as well. On that basis, a tax on royalty would not be a tax on mineral rights and would therefore, in any event, be outside the competence of the state legislature.
Yes.
The Rajasthan, Punjab, Gujarat and Odisha High Courts have held that royalty is not a tax. See, so-and-so, so-and-so, so-and-so. It was contended. Now there is no discussion of these judgments at all, Manoj.
Right.
As to what they have held, what is their logic and what is the fallacy in those judgments. In fact, in Dr. S.S. Sharma's case, which I'll be placing, the validity of Section 9 had been questioned. That this is a tax and it's a usurpation of the power under 50. So the court said it's not a tax and therefore there's no question of usurpation. That's how it was said. Then 32, it was contended by Mr. Krishnamurthy that the state has a right to tax minerals. It was further contended that if a tax is levied, it will not be irrational to correlate it to the value of the property and to make some kind of annual value basis of tax without intending to tax the income. In view of the provisions of the Act as noted herein before, this submission cannot be accepted. Krishnamurthy also further sought to urge that entry 50, there is no limitation to the taxing power of the state in view of the principles mentioned herein before and the express provision of Section 9(2) or MMRD Act, this submission cannot be accepted. The field is fully covered by the central legislation. In any event, royalty is directly relatable only to minerals extracted. And on the principle that the general provision is excluded by the special one, royalty would be relatable to entry 23 and 50 list 2 and not entry 49 list 2. But as the fee is covered by the central...
Is it the field, I think, but as the field is covered.
Fee is covered by the central power.
Field.
F-E-E, fee.
F-I-E-L-D. It's a typo.
Oh, yes.
Just is a typo.
Where is the typo?
There it is a typo.
That also is.
As the field is
But
covered
as
by
the field is covered by the central power under entry 23 of or entry 50 of list 2, the impugned legislation cannot be upheld. Our attention was drawn to a judgment of the High Court of Madhya Pradesh, Hiralal Rameshwar Prasad, which was delivered by a division bench. Justice J.S. Verma, acting Chief Justice, as his lordship then was, held that the development cessed by so-and-so is ultra-virus. It is not necessary to, in the view taken by us further. Yes, oh my God. So, just pausing, my lord, up till para 33, there is no discussion, no debate, no issue raised by any side that royalty is a tax or not. Just the Mysore High Court judgment is referred and then the 4 High Courts holding otherwise is referred. Neither of them are discussed. Because if there are 2 sets of reasoning, my lord, it would be expected, my lord, if a bench of 7 judges to discuss and debate, my lord, which one is the right one.
No, earlier it was Karnataka.
And why Mysore should be adopted instead of the other 4. In fact, the 7 judges bench has avoided the question which of them is right. So my learned friend is not quite right in saying that while getting up the judge said, my lord, and obviously that is not on record, my lord, that it is this or it is that. At least I was not there, my lord, so I will go by the record. Now kindly see, my lord, the abrupt conclusion in the
Most
passage.
crucial paragraph.
34.
34 is the most crucial paragraph.
In the aforesaid view of the matter, we are of the opinion that royalty is tax. As such, cess on royalty being a tax on royalty is beyond. One can understand cess on royalty being a tax on royalty is beyond the competence. One can understand that part. But there was no issue. Issue was whether cess on royalty is good or bad. And the court is saying in the aforesaid view of the matter. So there is no view of the aforesaid matter in the previous paragraphs. Not a single sentence, not a whisper. And that's why Kesharam said, my lord, that if you say just this word is missing, in the aforesaid view of the matter, we are of the opinion that cess on royalty is a tax.
Correct.
So that's how, my lord, this clarified this apparent error. There was no issue. No issue has been framed in any paragraph that whether royalty is a tax or not. There is no debate, no consideration of the general concept of
If you
royalty.
read it like that, see, it's so obvious. In the aforesaid view of the matter, we are of the opinion that royalty is a tax